as he was brutally beaten to death while begging for his life.
I intentionally killed Dale.
She puts the car into drive, driving over one of them, the little year-old, obviously killing him.
That the state does not believe that William was died and dumped in the woods.
Angela Hicks married Steve Pankey in 1978 and later testified that life with him was marked by control and isolation. She recalled how he cut her off from her father, banned her from driving, and prohibited music, television, or radio in their home.
I was supposed to stay at home.
By 1984, the couple had a son, and Hicks believed they would not be visiting Pankey's parents for Christmas in California. But everything changed the day after Janelle Matthews disappeared from her Greeley home. Pankey abruptly announced they were leaving for California, dismissing Hicks's concern about their 2 Great Danes by saying the dogs were gone.
I was just shocked. Steve says, "Don't worry about the dogs are gone." I said, "The dogs are gone?" He said, "Don't worry about the dogs. The dogs, get us ready to go."
The trip was brief, and on Christmas Day, as they drove back, Pankey insisted on listening to radio reports about the missing girl. Instead of heading home, he diverted to a Safeway, bought newspapers with their last change, and had Hicks read every article about Jonelle aloud, each multiple times.
In my flipping around, came to a portion of a news report that had indicated that a girl had gone missing from Greeley, Colorado, and he wanted to hear that. And he asked me to read him the article about Janelle Matthews from that day's Greeley Tribune and from that day's Denver Post, and I recall him having me read each one at least 3 times.
Decades later, Pankey's behavior around that disappearance would place him at the center of a murder investigation. In 2020, he was indicted for Janelle Matthews' kidnapping and murder. His first trial in 2021 ended in a mistrial on the most serious charges, though he was convicted of false reporting. A retrial followed in 2022, where jurors found him guilty of second-degree kidnapping, felony murder, and false reporting. Pankey was sentenced to life in prison, with the possibility of parole after 20 years, making him eligible for release in 2040 when he would be nearly 90 years old. In June 2019, 26-year-old Lexis Stagg was at the West Chase Grand Apartments in Houston with her 2 daughters and a son. Surveillance video later showed her driving an SUV in the complex parking lot while the siblings followed along. At one point, she backed up a considerable distance and then moved the vehicle forward toward them. Her daughters managed to get out of the way, but her son was struck. He was taken to the hospital where he passed away.
I've never seen someone deliberately play with young children with a car. She puts the car into drive and drives directly into the group of 3 kids, driving over one of them, the little year-old, running over him with two wheels of her car and obviously killing him.
At first, Stagg told investigators that the incident happened when she accidentally hit a speed bump. However, after reviewing video evidence, prosecutors said the story did not match what really occurred. Stagg was arrested and charged with criminally negligent homicide. A magistrate set her bail at $1,500, much lower than the $50,000 prosecutors had requested.
One condition that I will without a doubt ask for is that she have no contact with her children until this case is over. She has proven in my mind that she is not fit to supervise those kids currently.
Child Protective Services confirmed a prior history with the family, and her 2 daughters were placed with relatives. If convicted, she faced up to 10 years in prison. In May 2023, 75-year-old Amadeo Amado Quindara, a Filipino-American living in Las Vegas, was attacked in his garage after a dispute with his neighbor Christian Lentz. Witnesses said the confrontation began when Quindara was speaking in Tagalog.
God. Oh my goodness. God.
The case was treated as a hate-motivated crime and drew attention from community groups advocating against anti-Asian violence. The legal process stretched on for 2 years, with several delays that left the Quindara family frustrated. Prosecutors argued the attack was fueled by bias, while the defense pointed to Lentz's struggles with mental illness. In August 2025, Judge Jennifer Schwartz sentenced Lentz to 90 days in jail, 5 years of probation, 3 years of mandatory mental health treatment, and ordered him to pay $7,000 in restitution.
Maybe if we weren't Asian, maybe this would have been a different sentence. He's going to get probation, fine, all right. But 90 days? The outrage is immense at this point.
Quindera and his family expressed disappointment, believing the punishment was too light for the harm caused, and questioned whether the outcome might have been different had the victim not been Asian. Still, they remained grateful for the support of advocacy groups like Bamboo Bridges, who stood by them throughout the case. Today, Quindera continues to live in the same home, determined not to let the attack silence or define him. In July 2024, Giver Essen of Pittsfield, Massachusetts, joined classmates on a summer program trip to Beartown State Forest in Great Barrington. The outing included swimming at Benedict Pond, where safety protocols quickly broke down. Instead of dividing students into small groups, as originally planned, all 35 students entered the water at once. Giver, who could not swim, was seen struggling. Other students alerted staff, but no immediate action was taken. By early afternoon, students began leaving the pond. When supervisors conducted a head count as students boarded the bus, they realized Giver was missing. A search followed, and she was found in the water at 1:58 p.m. Despite rescue attempts, she could not be saved.
When they called me first, they were like, they can't find her. I was like, what do you mean you can't find her? Then like 10 minutes time, she called again. She was like, oh, you found her? She was under the water. I said, which water? What was she doing there? Was she swimming? I said, who allowed you to let her swim? She's gone. I'm just waiting for the court to decide what next. Let's see what the court brings to us.
An investigation later revealed multiple safety lapses. No swim tests were administered, flotation devices were not enforced, only one lifeguard was present instead of 2, and a buddy system was never implemented.
We asked to waive the formal reading and enter not guilty pleas to the indictments.
In June 2025, a grand jury indicted program coordinator Linda Whitaker and site supervisor Megan Braley on charges of involuntary manslaughter, permitting serious bodily injury to a child and reckless endangerment of a child. Both pleaded not guilty when arraigned in August 2025 and were released on bail. Their next court appearance is scheduled for December 8, 2025, as the case moves toward trial. On New Year's Eve of 2018, 33-year-old Jorge Ledesma Echevarria was driving his family in a Chevrolet Tahoe along the Crosby Freeway in Harris County, Texas. At the intersection with the Beltway 8-feeder road, he ran a red light and struck another vehicle. Investigators later determined his blood alcohol level was .201, nearly 3 times the legal limit.
The 15-year-old has suffered a brain bleed that's going to require some pretty intensive medical intervention, and the wife has suffered a fractured pelvis.
The crash had devastating consequences. His daughter, Vanessa, was critically injured and flown to a hospital where she passed away about an hour later. Both his son and wife suffered a severe injury that required intensive treatment. Neighbors describe Vanessa as full of life and precious.
My heart, is just broken, full of life, big personality, precious child. Precious child, I'm heartbroken. I'm waiting on my 11-year-old granddaughter to come back, to tell her that her best friend for the last 3 years, is gone.
Authorities charged Echevarria with murder in connection with Vanessa's death and with 2 counts of intoxicated assault for the injuries to his wife and son. His bond was set at $200,000. In August 2023, Eastern Market CEO Dan Carmody and his wife Vivian were walking to dinner in Detroit when they were struck by a car at the intersection of East Lafayette and St. Aubin. Police say the driver, 28-year-old Jacob Moralak of Romulus, had been traveling the wrong way, ran a red light, and lost control, causing the crash. Vivian did not survive, and Dan suffered serious injuries.
The defendant was driving the wrong way down 2 separate streets with large grassy medians. He ran a red light, proceeded to drive onto a sidewalk, struck 2 pedestrians, struck numerous other objects, continued some 400 feet.
Morolak was arrested and charged with operating while intoxicated, causing death, reckless driving, causing death, and related counts for causing serious injury.
The court will enter a not guilty plea on behalf of your client. These are very, very serious allegations. I'm sure these are just allegations, but they're very, very serious, allegedly causing the death of one person and the serious injuries of another.
At his arraignment, bond was set at $250,000 cash, and prosecutors noted his high level of impairment. After a year of court proceedings, a jury found him guilty on all charges in September 2024. The following month, he was sentenced to 7.5 to 15 years in prison. In April 1997, 25-year-old Kathy Parisi, a mother of two from Cleveland, vanished after leaving for an escort call in Parma. She never returned, and her car was later discovered at a shopping center off EI 480 with her keys and some cash inside. Despite years of searching, her body was never found, and the case eventually went cold. Decades later, in April 2024, a grand jury secretly indicted Michael Bukowski of Toledo in connection with her disappearance. He was arrested in January 2025 at the age of 50 and charged with multiple counts, including murder, abduction, gross abuse of a corpse, and tampering with evidence. Kathy's daughter, Angelina, described the arrest as overwhelming, bringing both relief and renewed pain as old wounds reopened.
I kept saying I felt like my ears were ringing for like a couple of days, and I was kind of in just blank at first. We are grateful for everything that is happening, but at the same time, it's very scary because it feels like it's almost like, are we just reopening something that was basically healing for all of us at this point?
Bukowski pleaded not guilty, posted bond, and was ordered to avoid any contact with Parisi's family or witnesses. As the case moved forward, prosecutors turned over key evidence to the defense in spring 2025. This included DNA samples, items collected from Kathy's car, photos of her personal belongings, and other forensic material. The defense responded with its own requests as both sides began preparing for trial. By July 2025, a trial date was officially set for April 2026, nearly 29 years after Kathy disappeared. In April 2023, firefighters and police rushed to Ricky Lynn's home on Fayette Street in Martins Ferry, Belmont County, after reports of a fire with his mother still inside. When they arrived, they found Lynn armed, refusing to cooperate. Officers used tasers several times before finally subduing him and taking him into custody. Investigators later charged him with attempted aggravated murder and aggravated arson, both first-degree felonies. Linda's preliminary hearing was initially scheduled soon after his arrest, but had to be postponed when his attorney withdrew and a new lawyer was appointed. Appearing by video from jail, Linda insisted he was exempt from any prosecution, a claim he said another lawyer once made to him. He also told the judge that poor eyesight prevented him from reading, writing, or making calls.
I have a problem because I can't see. My eyes are bad and I can't see nothing, so I can't call you or nothing. I can't use my pen. I can't see.
Judge Chris Berhalter advised him to work through these concerns with his newly appointed attorney. Linda's bond was set at $500,000, and the court later ordered a mental competency evaluation to determine if he was fit to stand trial. In July 2023, 32-year-old Joseph Banuelos Jr. walked into the Route 66 Travel Center in Albuquerque, covered in blood, and told workers he had harmed his father. Police later discovered his father, Joseph Banuelos Sr., inside the family's home. Banuelos Jr. was arrested and charged with murder, making his first court appearance the following Monday. The hearing was brief, and he remained silent as prosecutors filed a motion to keep him in jail while the case moved forward.
A motion for pretrial detention has been filed. I will sign the order of transfer.
Court records revealed a long history of troubling behavior. In 2015, his sister accused him of harming her. Though the charges were dropped, more incidents followed in 2020 and 2021, which ended after he completed a court program. Then, in October 2022, he was arrested 3 times in 1 month. In one case, his father reported being threatened, while in another, his mother said he broke into their home and she feared for her safety. Documents also showed he had been diagnosed with schizophrenia, but was not consistently taking his medication. Banuelos Jr. eventually pleaded guilty to a breaking and entering charge, with other counts dismissed on the condition that he complete a mental health program. Following his July 2023 arrest, a judge ordered Banuelos Jr. held without bond. The Albuquerque Police Department has since closed its investigation, though no public reports confirm a trial verdict or sentencing at this time. In July 2022, Troy Kohler was reported missing from his home in Spring, Texas. His adoptive mother, Tiffany Thomas, called deputies early that morning, but the search ended tragically when Troy was found dead inside the family's house. Investigators soon turned their attention to Tiffany and her husband, Jermaine Thomas, uncovering troubling text messages and a history of concerns from Child Protection Services. By the end of that year, Jermaine was charged with capital murder and Tiffany with to a child by omission. Their bonds were set at $2 million and $150,000 respectively, and both remained in custody as the case unfolded. Over the next 2 years, prosecutors built their case. In February 2025, Tiffany pleaded guilty to the lesser charge of to a child, with sentencing set for September 10th, 2025. A few months later, in July 2025, Jermaine accepted a plea deal and was sentenced to 50 years in prison. In February 1999, cemetery workers in DeKalb County, Georgia, discovered the remains of a boy in a wooded area near a church. The body was dressed in jeans, a hoodie, and Timberland-style boots, but because of the condition of the remains, no one could identify who the boy was. For more than 2 decades, the case remained a mystery. That mystery was finally solved in 2022. Investigators, using modern forensic techniques and fresh leads, identified the boy as William Deshaun Hamilton. Once his name was revealed, investigators focused on his mother, Teresa Ann Bailey Black, who had moved with William from North Carolina to Georgia around the time of his disappearance. She was arrested in Arizona and extradited to Georgia, where she faced charges including murder, child aggravated assault, and concealing the death of another. The trial began in January 2024. Prosecutors argued that William had shown signs of illness for several days, but Teresa did not take him to a doctor. Instead, they said she gave him medicine at home and later left him in a wooded area when he passed away. They also pointed to inconsistencies in her statements over the years, suggesting she had tried to hide what happened.
When we speak about reasonable doubt, let's think about it this way. Is it reasonable that this defendant, who knew something was wrong with her son William for a few days, who observed the following symptoms of her son over a few days: lethargic, weak, tired, gagging, didn't want to talk, didn't want to walk, didn't want to do anything? Is it reasonable for a parent to see these symptoms for a few days and not seek medical attention? I submit to you the answer is not. Parent may see one symptom, maybe 2. But you have 7 different symptoms up here that this child is experiencing over a period of few days, and that came from this defendant's mouth. And she failed to seek medical attention. And because of that, William is no longer here with us today. The state also has to prove venue. Venue is the location where we can say the crime happened. We're here, venue is DeKalb County. We have to prove that this case, that venue relies in DeKalb County. I want to let you know that if a dead body is discovered in this state and it cannot be readily determined in what county the cause of death was inflicted, venue is proper and may be proved in the county in which the dead body was discovered. I submit to you, and I'm going to say it now, that the state does not believe that William Hamilton died in that wooded area and laid there for decomposition. I submit to you that William was driven there and dumped in the woods with his Timberland boots on, double knotted as defense counsel stated, and left there. We know he didn't sleep there from a plethora of reasons, but one that was very, very important was that canned bottle that had his shoe imprint in the wooded area. Is it common sense to believe that he slept on that canned bottle when he went to sleep that night? Because the indentation of the canned bottle was that of his boot. I submit to you that if he slept there, meaning that Teresa, this defendant, and William got off a bus and they walked to a location in the wooded area to get off the street and slept on pine straw during the cold, when she previously advised you that she slept on park benches, that she slept in the park and at bus stops, she's not going to go to a wooded area full of pine straw to go to sleep. And William's leg is not going to be so comfortable that his boot is sitting on a can while he's resting. So I submit to you that this body was dumped in this wooded area in our jurisdiction in DeKalb County, and that is where venue lies. There's also another portion of venue that we have to prove as well. In any case in which it cannot be determined in what county a certain crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. So I want to talk to you about, I'm going to touch on briefly and I'm going to come back to it, but concealment of the death, right? She concealed it and she lied about it. She placed the body in a wooded area. She told you she either took a jacket or a sweater and she laid it on top of him, covering up his body, concealing. And then she lied about it. She lied about it continuously over and over and over again. And the lie started at the very beginning. The lie started when she made that phone call to Ava from a payphone. And I submit to you that during her statement, she stated when she got here she was living in the Decatur area. And she used a payphone, and she stated that William was in a room with friends, and that's why Ava couldn't speak to her. But she told you all through her statement that she lived in the Decatur area, which is in DeKalb County. There's no area outside of Decatur, Georgia, that is not located in DeKalb County. And she told Ava a lie. She told Ava, oh, William, he's in the room with my friends. She just got to Atlanta. What friends she got? She don't know nobody. William did. And at that moment, she told a lie, starting a cycle of lies and continued the lies for decades. But the lie began in DeKalb County with Ava. And so I have to prove that venue lies in DeKalb in reference to that charge as well. And I want to go ahead and kind of give you all a preview of that information as we progress on through the closing argument. So here's the location where William was found. Right? And you heard from multiple witnesses that the body was located somewhere along this wooded area. There's a path, and you can actually see a vehicle right here. There's a path in which cars can travel within that wooded area. And here is an entire cemetery that ironically this defendant never saw when she told you all she slept there. And then she stayed there for a day or two watching over William as he lie there dead. She never noticed there was an entire cemetery there. And you telling this jury that you've been there for over 24 hours watching your dead son. So then, let's talk about her intent. I want to be clear. In order for the state to prove intent, which we have to do, I want the jurors to know that it may be inferred from proven circumstances by any acts or conduct. I can prove this defendant's intent through her actions, through her conduct. And in your discretion, you can also infer logical conclusions about her acts or conduct, and you can look at it and see if her actions or conduct results in the natural and necessary consequences of those acts. So, for example, this defendant gives her child some medicine, some acetaminophen and diphenhydramine, because there may be issues going on or because she needs him to sleep. And then he begins to exhibit symptoms from these drugs. And she tells you in her statement, I will give him anything I can find. She subsequently over-medicates him. You can draw the logical conclusion that that medication that was also found in his skeletal tissue, coupled with her statement that she gave him the drugs, without seeking medical attention.
The defense reminded jurors that the events took place more than 20 years ago and that the exact cause of William's death could not be clearly determined. They argued that the state had not met the burden of proof required for the most serious charges. After nearly 9 hours of deliberation, the jury delivered its decision.
Jury find as to count 1, felony murder. We the jury find the defendant, Teresa Black, not guilty. As to count 6, concealing the death of another, we the jury find the defendant, Teresa Black, guilty.
Teresa Black was acquitted of murder, child cruelty, and assault, but she was found guilty of concealing her son's death.
25 years ago, the body of a little boy was discovered in a wooded area off Clifton Springs Road and Clifton Church Road. An autopsy determined that his remains had been left there, exposed to the elements for 3 to 6 months. Because of that, investigators could not easily determine who he was, nor how he ended up there in February of 1999. Despite combing every inch of the area for clues and sharing details with the public about the plaid shirt, red jeans, and brown Timberland boots that the boy had on, no one came forward to identify him. He became known as Clifton Doe, a reference to the area where he was abandoned, and that name stuck for more than 2 decades. But investigators, family, and friends never gave up. While investigators were trying to identify Clifton Doe, family members and others close to William kept looking for him. It wasn't until 2020 that the searches for Clifton Doe and William Deshaun Hamilton would converge. A former neighbor and family friend recognized the unidentified boy as William, thanks to an updated facial reconstruction rendering from the National Center for Missing and Exploited Children, also known as NCMEC. That tip quickly led investigators to William's mother, Teresa Ann Bailey Black, who was indicted in her son's death in 2022. And I appreciate those of you that were here to cover when we had that press conference and we stood in this room on that day where we were able to finally say his name after so long. But today, a DeKalb County jury convicted Ms. Black on a charge of concealing the death of another and acquitting her of felony murder charges. While we respect the jury's verdict, I would be lying if I didn't say we weren't disappointed. We still believe she is responsible for young William's death. We are glad, though, that Teresa Black will be held accountable. For decades, she tried to hide the truth about what happened to her son, and that decision had far-reaching effects. People here in DeKalb County and across the country spent years working to find the truth, identify the little boy left in the woods, and return him to the family so that they could lay him to rest in the manner that he deserved. Teresa Bailey may have walked away and abandoned her son in 1999, but today I'm proud to say that the people in this room and in this community never did. Today, William Deshaun Hamilton has his name back, and he will never be forgotten. Sentencing for Ms. Black is scheduled for Friday morning, and under Georgia law, she could face anywhere from 1 to 10 years. While we cannot get into the specifics today, I can say that we intend to seek prison time for this felony conviction.
The judge later sentenced her to the maximum of 10 years in prison for that charge. Although the case did not end with a murder conviction, it finally gave a name to the boy who had been unknown for so long. After 23 years, William Deshaun Hamilton's identity was restored, and the court acknowledged the failure that left him hidden in the woods. On the night of August 10th, 2025, 29-year-old Nateria Smith ran out of gas while driving along I-696 near Hoover Road in Warren, Michigan. She pulled her car to the shoulder and began refueling with a gas can. Moments later, she was struck by a passing Chevrolet SUV. The driver didn't stop, and Smith tragically lost her life. Police launched an investigation and quickly recovered vehicle parts left at the scene. These led them to a damaged Chevrolet SUV parked near Hoover and Martin Roads. The vehicle was traced to 36-year-old Megan Hamilton, a longtime Warren resident. Detectives said Hamilton and her husband cooperated when officers arrived, handing over the keys and allowing access to the SUV. 3 days later, Hamilton was arrested and arraigned in the 37th District Court.
Hamilton, you're charged with 1 count of failure to stop at scene of accident resulting in serious impairment or death. It alleges that on August 10th, 2025, you did being the driver of a Chevrolet Trax who knew or you had reason to believe that you had been involved in an accident on I-696 in Hoover, property open to the travel by public, did fail to immediately stop the vehicle at the scene of the accident and remain there until he or she complied with the requirements of MCL 250.619 and report the accident to the nearest, most convenient police agency or officer to comply with requirements of MCL 2.5.619. When there was reasonable and honest belief that remaining at the scene would result in further harm and the accident resulted in serious impairment of a body function or death of Nateria Santanique. That is a 5-year felony. If you are found guilty, you could face up to 5 years in state prison. Do you understand the charge?
Yes, ma'am.
Do you understand the potential penalty if you are found guilty of this charge?
Yes, ma'am.
I'll go ahead and enter a not guilty plea on your behalf at this time. I will refer this for court-appointed counsel. I'm sorry, you are retained attorney here. I apologize. Mr. Clements, you get the dates for the next court dates yet or not?
No.
All right, you are entitled to a probable cause conference. It's a pretrial with your attorney in front of a judge within 14 days. That is set for August 21st. That's a Thursday. August 21st. That will be in front of Judge Beta. That will be at 8:45 a.m. You're also entitled to a preliminary examination. That's where the prosecution will call witnesses to prove there's probable cause the crime was committed and probable cause that you committed it. That will be on August 28th
Hamilton was charged with failure to stop at the scene of an accident resulting in death, a felony punishable by up to 5 years in prison. In court, she entered a not guilty plea. During the hearing, prosecutors stressed the seriousness of the case, pointing out that Hamilton did not stop at the crash scene and was only identified through investigative work. Her attorney, meanwhile, emphasized that she had no serious criminal record.
What I'd ask the court to consider on behalf of Ms. Hamilton is that she presents before the court at 36 years of age. She has little to no criminal history. I of course, am limited to what I can do in terms of a background search to be eye chat and things of that nature. I didn't see any significant or serious felony history, any significant or serious misdemeanor history. My client does have a valid license. She's gainfully employed. She's worked at Chrysler for 15 years. She's been a resident in a single-family residence in the city of Warren for 7 years. Of course, I bring these issues to light so that the court can have confidence that she does have significant ties to the community. The minor children that she supports, the number is 7. So she's got all the reasons to continue to go to work, all the reasons to appear. Her family has assisted her in retaining counsel in this particular matter. As it relates to what happened when the police encountered her at her home, she was cooperative with them. She answered questions from what I understand, at least as she relayed to me. Her husband was also cooperative with authorities as well. They asked for access to her vehicle, it was provided. They asked for the keys to her vehicle, it was provided as well, as I understand. So I think that the court can have confidence that these are individuals that are cooperating with the system, that they will abide by any terms and conditions that the court sets forth. I'm asking the court set bond in this particular matter at $5,000 cash surety. And I believe that that's a fair and reasonable bond given the circumstances.
Mr. Urban, on behalf of the people, what would you like to tell me?
Yes, Your Honor. On behalf of the people, this matter obviously, the nature of the charges, they are serious. At the end of the day, it is alleged that there was the deceased in this matter was stopped on the side of the road on the expressway, and that while I believe attempting to fill her car with gas or to deal with a vehicle issue, she was struck. That vehicle that struck her allegedly then continued to drive and went back to their home. Your Honor, the fact that there is a death in this case obviously shows the seriousness of the nature of the charges. We do have concerns about her ability or ability, I guess ability is the best way to say it, to come to court. When asked to, when considering when she was encountered with being in an accident, she did not stop, she did not call police. The only way that the police became aware that it was her was after doing a series of investigation involving car parts that were left at the scene, canvassing the area, and going to eventually finding a vehicle that matched the description, matching damage that would be indicative of this type of crash, and then making contact with that individual. That is worrisome, and it shows that there is obviously a risk of flight if she's willing to drive away from this. While it is true that there is limited criminal history, we still believe that this conduct is dangerous and that there is a risk of flight, and obviously, unfortunately, due to this defendant's conduct, someone did lose their life. We would ask for a substantial cash bond in this matter due to that flight from the scene of the crash while this case is pending.
Were there, obviously, I know limited facts, and she's innocent until proven guilty. However, I know there was a delay between the accident, her taking off, and the arrest. Are there any blood work going? Do they think is there a cause? Did they do any blood work?
Your Honor, I believe there was a blood sample taken in this matter. At this time, we do not have that, obviously, as this occurred 3 days ago, and it would take some time for that to be processed by Michigan State Police. So at this time, we are not aware of there being any type of substance, whether it be alcohol or controlled substance or otherwise. But I do see within my file that a search warrant for Ms. Hamilton's was drafted, signed, and I believe executed.
Officer?
Yes, there was a search warrant for the no other comment.
All right. For purpose of bond is twofold. It's for the
Judge, may I add one thing? My client did submit to a PBT voluntarily, albeit it was after the fact. So the
like 9 hours after the fact.
Correct.
Okay,
Yes.
I appreciate that. The purpose of bond is twofold. It is for the protection of the community. It is for reappearance. I am very concerned about both of these issues. I don't know. There was a blood draw. I don't know how long it will take to get back. If that, I don't know if it will. If it won't, it may not. But if it does come back, they're looking at even much more serious charges. If there was anything in your system, I don't know what could cause someone driving on a freeway to smash into somebody who's just innocently filling up their gas tank on the side of the road. I hope there wasn't, but I don't know. And I'm concerned about behavior, conduct following the accident and fleeing to a home. And again, had but for them finding her, she was not turning herself in at that point. I am sitting the bond at $50,000, cash and surety only, with GPS tether before release. There will be no alcohol, no drugs, and there will be testing.
Was that 15 or 50?
50. 50,000, cash and surety only, GPS tether before release, no alcohol, no drugs, and there will be testing. This case will be assigned to Judge Pita during another bond review.
The judge set bond at $50,000 cash, requiring Hamilton to wear a GPS tether, avoid alcohol and drugs, and undergo random testing. While the legal process moved forward, Smith's family mourned her loss. Her mother shared that just the night before, they had been making plans for her daughter's upcoming birthday, a painful reminder of how quickly everything changed. Now, the case continues through the courts, with Hamilton facing the possibility of prison and a grieving family seeking justice for Neteria Smith. In early 2024, 55-year-old Mark Newsom was living in a Roseville, Michigan boarding house with several other men. Among them was 72-year-old Dale Mitchell, who, according to residents, often acted controlling and confrontational. On January 31st, 2024, tensions flared when another resident accused Mitchell of stealing a Taco Bell meal. Newsom, who had been asleep, woke up to the commotion and confronted Mitchell. What began as a verbal dispute quickly escalated into a physical fight. Witnesses reported that Newsom struck Mitchell repeatedly. When police arrived, Mitchell was found unconscious and later died at the hospital. Newsom was arrested and originally charged with second-degree murder. Prosecutors argued that the assault was excessively brutal.
Your Honor, the agent that wrote the report scored Mr. Newsom 50 points under offense variable 7, which is called sadism, torture, excessive brutality, or conduct designed to substantially increase the fear and anxiety a victim suffered during the offense. In this case, the deceased, Mr. Mitchell, his heart stopped during a fist fight. We don't think sadism was involved, nor was torture, nor was excessive brutality, and there's certainly nothing in the record that would indicate any of those things were designed by this defendant to increase fear and the conjunctive and anxiety the victim suffered prior to his demise.
Mr. Sergeant, counsel for the prosecutor.
Yes, Your Honor. Evidence showed that the defendant was found upstairs on top of the victim by a witness who observed the defendant consistently punching the victim, Mr. Mitchell, in the head while making statements of him. In addition to that, the victim did die from his injuries. The defendant hit him with enough force to render him unconscious, triggering a cardiac episode that would not have occurred but for the blunt force trauma that he had faced at the hands of this defendant, which also ultimately caused him to die. There is a case law that supports...
So let me interrupt you. Which leg of the elements of OB sentence, of OB 7, are you relying on? Excessive?
Yes.
So does that, you would agree it's that sadism, torture?
Correct.
Counsel? I asked you a question.
I said yes, Your Honor. Yes.
All right. Anything else?
Your Honor, there is a case, unpublished opinion, People v. Bell, on 5/22/07, number 269517, which scored 50 points on OV7, showing that the defendant was struck 5 times with the defendant struck the victim 5 times with a baseball bat, causing the victim to die of multiple blunt force injuries to the brain, triggering a heart attack. Also, at the appropriate time, Your Honor, I just want to let you know we do have a victim's impact statement.
Is there any evidence suggesting how many times the defendant struck the victim?
Your Honor, in the preliminary exam transcript, the witness testified that he heard the defendant, he heard what he believed to have been skin slapping, is what he heard. And he heard this going on for a little bit. When he went upstairs, he heard this continuing. He saw it continuing. He tried to get the defendant to stop. The defendant refused to stop and continued on after the victim, or after the witness went downstairs and called 911.
So many is what you're arguing?
Yes, Your Honor.
And we concede there were many strikes, Your Honor, but we don't know the number, and we don't have anything that indicates those many strikes were occasion to increase the victim's fear and the victim's anxiety. So we think that
The court believes that this is probably a classic example of excessive brutality and certainly designed to substantially increase the fear and anxiety a victim suffered during the offense. His fear level had to be off the charts as he was being beaten to death.
The defense emphasized Mitchell's poor health, which included serious heart and kidney problems, claiming these conditions made him more vulnerable and contributed to his death. In May 2025, Newsom reached a plea deal, entering a no-contest plea to manslaughter. The original murder charge was dropped. At sentencing on September 3rd, 2025, Newsom gave statement in his defense.
Me?
Yes.
Yes, Your Honor. There's some discrepancies in a lot of this. This has been very difficult for me. I have a hard time understanding the court processes. I've never been in trouble before. You know, this was a terrible thing. You know, I worked in group homes. I resided in them and worked in them. And I helped people, and I was helping everybody there. I didn't hate that. I was trying to help them. I helped everybody there.
Trying to help him with your fist, sir?
No, Your Honor, not at all. Being a friend. I'd go to the store and buy him stuff. He wouldn't even ask and I'd buy him things. Reminding him that, you know, to take his medicine. You know, because that's what I did at the other group homes. I just basically helped people. Dale Mitchell had some underlying mental issues that were pretty consistent and bad, and what I've seen in other group homes was a lot like schizophrenia. It was a bad thing. You know, he physically would go after everybody. I mean, I even have a statement to the police from Robert McQuaid of them beating on him. And Robert McQuaid stating that this would have never happened if the group home would have, whenever anybody was a threat at these other group homes, they'd be immediately removed, especially if they physically attacked anybody. And over again, Dale was going out there and hitting people. He hit me that night. Another thing that the court does not know is from the beginning, he said, "Graze my ear." No, he hit me in the ear, and that's what resulted me to swing on him, because it hurt really bad. And the hospital that night barely looked at my ear when I said something. But the jail had sent me to a specialist to an unrelated incident where my orbital, my eye got shattered by somebody that sucker punched me.
Go ahead.
That sucker punched me. And I'm sorry, I got thrown off the track here. And I couldn't just let Dale punch me in the face. And what I was trying to get at is there was new evidence that he had ruptured my eardrum. This is something that the court did not know. And they pulled the This is just a few back last August, I think. And 2 officers were standing there and see her pull the off. My ear started pouring blood. I didn't even say nothing. She said, "Who punched you in your ear? You got punched in your ear." And so that means I was telling the truth from the very beginning. You know, Your Honor, I'm 55. I don't have any criminal record. I didn't intentionally bail. I had, next to my bed, I had what I call the Dale wall that I made because I did not trust them. That's another thing. I was backed into a corner. Everyone had a bedroom but me. I was upstairs, and I didn't have a room to where I could close the door and get away from anybody. And Dale was ordered 2 days before by a police officer owns a group home. That was part of the reason why I wanted to be there. Dale went after me 2 days before and tried to punch me in the face in the kitchen with the prosecutor's witness, Christian Lee, was standing right next to me. I didn't even call the group home owner. Christian Lee did, and told the group home owner that Dale went after me and tried to punch me in the face. And the group home owner called me the following day and apologized to me and said, "We're trying to get rid of Dale. It's been too much. I can't have this anymore." And he's a police officer, by the way. And he told Dale didn't come upstairs anyway. He was a compulsive smoker, so he stayed by the front door. But he told Dale to not go upstairs anywhere near me anymore. Dale had a duffel bag with all his stuff downstairs, so why was he even upstairs when he was ordered not to be up there with him? You know, I got dragged into this. You know, Christian, that's another thing is, you know, Christian Lee has some psychological problems. He has Asperger's, and there's something else, and a heavily drinking problem. Now, on Dale's autopsy report, you know, they kept accusing me of being on drugs. I was the only one not on drugs, and there's proof of that. Dale had marijuana. You know, Christian would party with Dale. He had no business doing so. He was 27 years old. He was giving him psychedelic mushrooms, trazodone, and they're constantly drinking, which wasn't allowed in the home, which I believe helped result in all this, what happened. Now, Dale, I have a bad heart. I'll get that in a second. I've had open heart surgery, and I'm familiar with heart conditions. Now, Dale had left ventricle hypertrophy, which is thickening of the walls of the heart, and he wasn't taking his medicine. It was stacked up on the refrigerator, a foot high. He was only taking the trazodone. I don't know if that was his or if Christian was giving it to him. He was compulsively smoking Marlboro Black cigarettes, and he had pneumonia really bad in his upper left lobe of his lung on the left side. Mr. Haddad stated of the other health problems he had. I can't describe on how sorry I've been for this. I've never been to jail before, and I've had a lot of nights to sit and think about it and my relationship with God and how what this has done to my family. And the news made it look bad, like I killed somebody over food. This has been a really horrible experience for me, and I never intended for Dale to die. You know, a lot of this was mental illness, and it's a sad thing, and I've seen it a lot before in the other group homes. I've been attacked before. That's why I wear an eye patch. There was cameras there, so that's why that guy went to jail that did this. I could not let Dale just me in the face. I mean, I let him get away with swinging on me many times before. I was only there for 3 months. And, you know, I was backed in a corner up there. There was nowhere for me to go. That's another thing I wanted to state is Christian Lee said I was on top of him, beating him. I wasn't. Dale had a hole in my hoodie. I do believe when I called 911, I was holding him down. He was still trying to punch me. And I did not cause any damage to him. I was careful not to hurt him by holding him down. Dale was a lot bigger than me. He was 6'1" and 171 pounds. I was really sick at the time. I was 111 pounds. No sleep for a couple of days from being in the hospital. I mean, this thing has been such a whole mess, Your Honor. And I'm so sorry.
All right, Ms. Trace, you had a victim that wanted to say something?
Yes, Your Honor. It is going to be read by our victim advocate.
Mitchell's family also delivered an emotional victim impact statement.
I'm reading a statement on behalf of the family, authored by,
I didn't hear your name.
that's all right, Michelle Van Lawn, crime victim rights advocate at the prosecutor's office. I'm reading a statement prepared by the victim's former wife, Vicki Mitchell, on behalf of their family. Your Honor, we, the family of Dale Mitchell, wish to express the profound loss we have endured during the senseless murder of a beloved stepfather, grandfather, and friend. Dale was a man loved and respected by a wide circle of friends who, like us, are now grappling with the void of his death that has left in our lives. Dale's health had declined, leaving him more vulnerable and unable to defend himself from a beating so severe it took his life. The man taken was not a threat to anyone. He would never harm a soul. His friendships were the foundation of his life, and he was a man who would go to great lengths for those he loved. He was a steadfast friend who valued the people in his life, and those who knew him cherished his company. To take his life in such a violent and senseless way is tragic beyond words. This loss is particularly devastating because the good times spent with family and friends are replaced with horrible visions of the terror and pain he must have experienced as he was brutally beaten to death while begging for his life. It is difficult to comprehend. Dale deserved to live life until he died of natural causes. He was looking forward to having an apartment of his own that we had already filled out the paperwork for. We know that no amount of punishment or sentence can ever bring Dale back, but we ask the court to impose the maximum sentence, understanding the depth of our grief, the brutality of the attack, and the irreversible harm done to us, and the many others that have been negatively affected by this act of violence. We ask that the court take into consideration not only the brutality of the attack, but also a thought to the next time the defendant loses his uncontrollable temper. Respectfully, Vicki Mitchell.
All right,
Thank you, Your Honor.
They described Mitchell as a beloved stepfather, grandfather, and friend, emphasizing the deep void his death left in their lives. They urged the court to consider the needless nature of his loss.
If there was a book of senseless crimes, this would truly be at the top of the list. To take a man's life over a Taco Bell meal that wasn't even the defendant's meal is beyond senseless and heinous. The court struggled long and hard with the sentence agreement negotiated between the prosecutor and the attorneys, and seriously considered not following that sentence agreement and exceeding the guidelines. But somewhat reluctantly, the court will follow the guidelines in spite of the savage and caused by this defendant. It is the sense of the court that the defendant be committed to the Michigan Department of Corrections for a period of 5 years to a maximum of 50 years. Accordingly, he received credit for 581 days. He's to pay a $68 state cost, a $130 crime victims' rights assessment, court costs of $750. Any other conditions, Ms. Trace, that you recommend?
No contact with the family.
And no contact with the family. Sir, you're entitled as a matter of constitutional right to file an application to appeal your conviction and sentence. If you're financially unable to provide counsel to perfect such appeal, this court will appoint counsel for you. Request for assistance of counsel must be made within 6 months. This is your signature on the advice rights form, sir.
Yes.
That is all.
The judge called it a crime that should have never happened and noted the absurdity of a man losing his life over a fast food meal. Newsom was sentenced to 5 to 15 years in prison with credit for 581 days already served and was ordered to have no contact with Mitchell's family. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.